thinking about doing a last will and testament? Well, if you have, this basic estate planning guide, part 2, will provide some very, very valuable information for you. If you're thinking about doing a will, you should consider 2 specific areas of planning. I'm attorney Vernita Williams. Many times people come to my office and they say, I want to do a last will and testament. And as I speak with them, they gain a better understanding that it's not just a will that they want to do, but they need to do some other things as well. I explained to them that there are 2 specific areas of planning that they should do to make sure they cover their bases better. The first area is incapacity planning, and the second area is estate planning, which contains the last will and testament. The incapacity planning is a type of planning that you will do in which you designate someone to assist you with your business and personal matters if you're not able to do so. Normally that will entail doing a living will, which states whether you want to be on life support, a medical power of attorney, which states who should talk to your healthcare providers, and a durable power of attorney, which states who will handle your business and financial matters if you cannot. Those documents fit under incapacity planning. Now, in this part 2 of the Basic Estate Planning Guide presentation, I want to talk more about the estate planning aspect, because remember, I'm saying plan in 2 areas, the incapacity planning area and the estate planning area. Now, under the estate planning area, there are 5 basic things that I recommend. Now, not everybody will need all 5 of these things, but most people will select 2 or 3 out of the 5 things that I'm getting ready to tell you now. The first thing is a last will and testament. One of the things I want to emphasize about this last will and testament that fits under basic estate planning is this. If you do a last will and testament, yes, your family will need to go to court. A lot of times when people write a will, they think that means that their family won't need to go to court after they pass away. If you write a will, your family will need to go to court, but at least the court will know what you want to do. Now, if you're not a person who want your family to have to go to court, then the next thing might be for you. It is a living trust. Many people will choose to do a living trust rather than just a will because they don't like the idea of their family members having to go to court. Normally with a living trust, there is no court appearance. There is no court case. So with the living trust, you're not going to court. Plus, with the living trust, you have a lot more control and a lot more privacy because you didn't create a court case for folk to be nosy and go up there to the courthouse and say, I want to look through this person's file. So with the living trust, there's no court intervention unless there's litigation concerning the trust, but usually there's no litigation and no need for a court case. You also have privacy and a lot more control. So that's the second thing that one can do under estate planning. The third thing is perhaps a joint tenancy deed. A lot of times people come and say, well, I know I want my son or my daughter or my niece or nephew or cousin or sibling to have this property that I own if I were to pass away. So sometimes they can create a joint tenancy deed in which they put the other person on the deed to the property. Now, this can work very well provided you deed the property correctly, you describe the type of ownership as a joint tenancy with right of survivorship, and I don't recommend you do that on your own. Please hire an attorney to do that for you. But whenever you do a joint tenancy deed, it is very important that you understand who you are putting on the deed to your property. If that person has a lot of financial problems, then maybe you don't want to put them on the deed to your property during your lifetime, because you don't want your property being looked at as possible creditors of theirs who are trying to find an asset to sell to get their money. Plus, if you think you might change your mind about this person in the future and you want them to come off of the deed to your property, then you're going to need their cooperation to come and sign another deed to take their name off. So once you put a person on the deed to your property, you kind of lose a little bit of flexibility. If you want them to come off for whatever reason, they will have to cooperate. I've actually done these types of deeds for people and they changed their mind and they wanted to bring the person off of the deed to take their name off. And sometimes people cooperate and sometimes they don't. So be very careful with this joint tenancy deed. The fourth item under estate planning is the Totten Trust. The Totten Trust is named Totten Trust because the attorney that created it, his name is Totten. It is that basic pay on death form that you fill out when you open a bank account and they ask you if you want to list any beneficiary. Well, it's that beneficiary form that is at the bank. If you have a bank account, it's an extremely good idea for you to list a beneficiary now. When you list a beneficiary on your bank accounts, those accounts are normally not subject to probate proceedings. Your loved ones that you listed as beneficiaries can just go to the bank, show their ID, show your death certificate, and receive the funds without having to go to court. Now, if you don't list a beneficiary, then more than likely those funds in that bank account will have to go through a probate court proceeding for them to get transferred, and that's really not the best way to go. The fifth thing is life insurance. So under estate planning, we have the last will and testament, if you want to go that way. We have the living trust. There's a joint tenancy deed, a Totten Trust or pay on death beneficiary designation form with the bank. And the fifth thing is life insurance. Now with the life insurance is more than an insurance policy to take care of burial. Your life insurance really should take into account if there's some kind of debts you want to pay off with life insurance proceeds. It should take into account the income that will be needed by your loved ones who survive you, how much money they need to live, how much could you have provided for them had you continued to live. It should take into account if there's a mortgage that needs to be paid off. Many times folk will will somebody a house that has a mortgage on it, and that house ends up going into foreclosure because a lot of times whoever was supposed to get the house in the will, they can't afford to pay the mortgage. So when you consider how much life insurance you need, look at the debt that needs to be paid off. Look at any income you want to provide for your survivors. Consider if there's a mortgage that you need to pay off. And also if there are children and grandchildren you would like to educate through life insurance funds. So those are some basic things you need to look at under estate planning. Remember, I advise that you do incapacity planning as well as estate planning at the same time. If you would like more information beyond this basic estate planning guide, please visit my website. It is vcwlaw.com. That is vcwlaw.com. There you can find a checklist of 25 things you can do to set your affairs in order, as well as other free downloads. If you would like to watch part 1 of this basic estate planning guide presentation, please visit my YouTube channel. You can find part 1 there. Also, if you would like to call me with comments, questions, or suggestions, feel free to call me at 786-831-9483. That is 786-831-9483. This has been a VCW Law presentation. Remember to go to my YouTube channel. There's a whole lot of other information about estate planning and about probate that you can find out that will be good information for you and your family. Thank you so much for listening.